Welcome back to Bottom Line Africa. Back to Kenya, where the Director of Public Prosecution has made fresh applications against the country's Deputy Chief Justice, Philomena Mwilu. Now, the Anti-Corruption Court last month stopped the proceedings against Judge Mwilu and her lawyer, Stanley Muluvi, on orders of the High Court. Justice Mwilu obtained the order after arguing that her appearance in the dock is part of the plan by President Uhuru Kenyatta to avenge her vote for the repeat presidential election in August last year. Investigations on the judge have mainly revolved around transactions involving the collapsed Imperial Bank, which is under receivership, and failure to pay taxes. Now joined by High Court advocate Steve Ogola. Welcome to Bottom Line Africa. Thank you for making time.
Thank you.
Now, as we've just mentioned, the Office of the Director of Public Prosecution has actually appealed to transfer the case to the Anti-Corruption and Economic Crimes Division of the High Court. What is in store in case this goes as planned, according to the ODPP's office?
First of all, just assessing from what you've read, it's very important that Kenyans depoliticize and de-emphasize the trial or the prosecution of the Deputy Chief Justice. It's a legal process, and therefore the affidavit that she had sworn in court, politicizing her prosecution itself could be a false start. But I think it's better to urge all Kenyans to process this matter strictly through legal lenses. But having said that, the decision to move the file to the High Court Division and Anti-Corruption Court is a strategic decision because of the quality of arguments. But I think what is more urgent now is this attempt to try and lift the conservatory orders that were granted by Justice Chacha Mwita in respect of this trial, which then effectively stopped the trial until 9th of October, when they will take directions on how to hear that application, because Mwilu's lawyers challenged the decision to prosecute this matter as a criminal matter. They argue that this is largely a civil dispute that should have been recovered in the civil courts, as opposed to a criminal offense which would have been prosecuted in the criminal courts. So that application is coming up for direction on 9th of October. But I think the DPP is raising a critical question. He's saying that conservatory orders impaired his work, and it is true. As a consequence of those orders, he was unable now to move the next step of requiring the DCJ to take plea. You know, as of now, she has not taken plea of guilty or not guilty. So the trial can't commence. So that's a drastic decision by any means that ought to have been made with the input and presence of the Director of Public Prosecution. That did not happen because the orders were given ex parte. He has a right to challenge that. We will wait to see what the court will say about that affidavit, about that application that is filed in court. My thinking is that since that file has a date, they will pick a date when it can be argued, I think either on 9th of October or maybe another date, but it must be dispensed with first, whether those orders can be lifted. But of course, if the orders are lifted, the conservatory orders stopping the prosecution of the DCJ, if they are lifted, then it means that effectively the DCJ will have take plea. You know, once she takes plea, then it would not be necessary to continue with that case at the High Court. So those are some of the niggling challenges that both sides must consider as the prosecution decides to push with the prosecution and the defense decides or sort of seeks to cushion the DCJ from taking plea. Yes.
Does this particular case actually compromise her work as a Deputy Chief Justice?
Certainly, yes. Although right now, the DCJ has some window of grace. She benefits from some grace in the sense that there are mere suspicions she has not taken plea. But already, you know, in terms of Article 166, if you look at the requirements for appointment of the Deputy Chief Justice and other judges of the superior courts, the requirement that you must be of an impeachable character, temperament, judgment, all these critical requirements other than professional competence have already been impeached. You get? Yes. So if she moves the level of taking plea, to be honest, and in terms of the Constitution, I don't think taking plea, although taking plea itself of not guilty, she's still safe within the boundaries of what we call presumption of innocence. But I think looking at it from the threshold of preservation of public confidence in that office, her ability to continue serving as DCJ will be significantly lowered, if you ask me. So yes, this case will disrupt her career. And in my thinking, if she takes plea, she must step aside. Which then brings to me the other question, which is more important. I thought that now that the High Court, Justice Chacha Mwita, already stayed the criminal trial at the lower court, that the Director of Public Prosecution, the DPP, would take time to reflect and reassure himself whether really he has what lawyers recall as incontrovertible evidence. Review his decision to prosecute. You see, the decision to prosecute a sensitive office holder, such as the Deputy Chief Justice, comes with unintended consequences. One of them, which you've already highlighted, the politicization of that case. Number two, it could effectively kill her career, whether she's eventually acquitted or not. Number three, it could batter the image of the judiciary because you have the number two in command within the rank and file of the judiciary, facing serious charges of corruption. The entire judiciary, there will be serious suspicions as to whether that judiciary is truly independent, truly functional, truly incorruptible. Because all these factors put together, the Director of Public Prosecution ought to have considered them, and maybe as a halfway measure or a practical sense step. Nobody is saying that the DPP cannot charge anyone. He can charge anyone. Because if you look at his powers under Article 157, he can charge anyone, in a court of law. But the decision to charge or the decision to prosecute when the persons involved are sensitive office holders must be tempered with reasonableness, discretion, and some halfway measures. I believe it would have been more strategic to liaise with the Judicial Service Commission under Article 168 to see if the JSC can review this evidence that the DPP has, and on its own motion, under that provision, Article 168, initiate procedure for removal, so that you're prosecuting a former DCJ, not a serving DCJ. There are serious legal and extra-legal implications in prosecuting the DCJ, which I'm hoping that the DPP ought to have considered, is considering, will continue to consider before he reaches the level of asking the DCJ to take plea of guilty or not guilty.
Well, you mentioned the Judicial Service Commission. How do they come into play in terms of whether Mwilu takes plea of guilty or not guilty? How do they actually come into play?
There is no connection directly in law because, you see, the functional independence of the Office of Director of Public Prosecution is demarcated in the law. He doesn't need to consult anyone when he's preferring charges. But you're preferring charges against someone who is also subject to other disciplinary measures, under the same constitution. So what we're talking about is harmonization of the processes. Yes, JSC can come in because the moment the DCJ is charged in court, takes a plea of not guilty, the JSC must convene and assess what is the implication of these charges? What do they mean for the judiciary? What do they mean for the DCJ? Do they need to initiate the process of removal, which means they must give her an opportunity to come and present her case again afresh before the JSC, for purposes of helping the JSC to establish whether they need to recommend the formulation of a tribunal or not. So you see, there may be some double jeopardy there, if you like, because the DCJ will be facing charges in a criminal court, but also facing separate parallel charges for removal, at the JSC. Which, to avoid all this duplicity and all this double jeopardy, if you like, for strategic reasons, it would have been better if the Judicial Service Commission had the first go, or the first bite at the cherry, assessing, because, their approach, the threshold there is far much lower. It's a question of perception at the JSC. But at the ODP, it's a question of evidence. Perception at the JSC means looking at this evidence on record, which the DPP has. Madam DCJ, could you please respond to these allegations in a manner that can satisfy us that your integrity has not been impugned? Then they will listen to her response. Then they'll make a decision whether to keep her or not. If they make a decision to keep her in service, it doesn't alter the DPP's own decision to charge her. If the DPP persists and decides to charge her, JSC will meet again and review the consequence of charging or serving DCJ. Then they may ask her to step aside. Stepping aside is just a common sense issue. Does not mean now that JSC is now, because they would have already examined the evidence available and reached the conclusion that she needs to continue serving. But when she steps aside, she'll be stepping aside to finalize her criminal case, and maybe the Chief Justice can liaise with the court handling her case to expedite the hearing so that either she's cleared or acquitted. If she's cleared, then she resumes work. If she's found guilty, then of course she'll be removed.
Now, the angle of a political witch hunt, which you said we must totally disassociate this with the legal proceedings facing the Deputy Chief Justice, is something that we still need to talk about, because she got reprieve till October the 9th on this particular move, where her legal counsel was actually able to raise this. How do we talk to Kenyans and actually inform them that this is simply about legal proceedings against the Deputy Chief Justice, nothing, absolutely nothing to do with the political witch hunt, yet she herself actually claimed that this might be one?
I think that was a tactical error in judgment on the part of the DCJ to try and politicize her case. But even without saying so, the public would have already politicized this case. We saw the odium wing of the political elite relating these charges with the political judgment or with the judicial, the Supreme Court determination following the presidential election petition. And they said there is a correlation, the so-called revisiting of the judiciary. It is very difficult to completely remove politics because politicians would want, they have a stake in the composition of the Supreme Court. Remember, Chief Justice David Maraga must retire before the next election. He must be replaced and another judge will have to be appointed. Now, the replacement of the Chief Justice, of course, the first contender is the Deputy Chief Justice, you know. So to get her there, to get her out of the way or to preserve her space there is a political process, it's a political debate. But I think what Kenyans must begin to understand is this. Reduce reliance on political conversation because you don't know the philosophy that informs the political discussion. I always urge Kenyans to avoid reliance or limit reliance on politics around the judiciary. Now, the predictable pathway is this. This in law is a legal process. There's an offense in law which has been established by the DPP. Now he's seeking to establish it with certainty in court. When the court says, yes, you've established your case, then of course, the DCJ will be convicted, she will be sentenced, part of the money that she's alleged to have received illegally and irregularly will be recovered from her assets, and the matter will end there. She'll serve a sentence, and the matter will end there. It will be a criminal matter. It is a criminal matter. But if she's cleared, then we can expect to see heightened political activity. Because, you know, the thing is this. Kenyan judiciary works in the context of a toxic political environment, where there are always this stubborn perception that politicians try as much as they can to influence composition of the judiciary, to influence the independence of the judiciary. If they can't influence it, to outrightly emasculate it. So there's going to be a critical balance, but let politicians play the politics because they'll always play the politics. But dear Kenyans, de-emphasize political machinations, de-emphasize political talk. Insofar as this case is concerned, I would like to urge you to limit yourself to the questions of law which the DPP is preferring in court. Okay. That perhaps is a better way to go.
Well, thank you. Well said, Steve Ogola, High Court advocate, perhaps shedding more light on this new charges, not actually new charges, but the new move by the Office of the Director of Public Prosecution to actually make an application in the High Court to transfer the DCJ's case, that's Philomena Mwilu, to the Anti-Corruption and Economic Crimes Division of the High Court. Thank you so much. Let's continue.